After my son-in-law emptied my business account of $187,000 while I was recovering from a stroke, he bought a boat and put a down payment on a vacation condo in Clearwater. 6 weeks later, he called me from the driveway of that condo, screaming so hard I had to hold the phone away from my ear. "You've destroyed my family. You've destroyed everything." My response was 3 words: "No, you did." I want to tell you exactly how it happened, not because I'm proud of all of it, but because I think a lot of people my age have been where I was, trusting someone they shouldn't have, and then told by the system that there's nothing to be done about it. I'm 64 years old. I spent 31 years building a small commercial HVAC business in the Tampa Bay area. Nothing glamorous. I drove a used truck, wore the same work boots for 2 seasons at a time, and reinvested every dollar I could back into the company. By the time I handed over day-to-day operations to focus on my health, the business had 11 employees, a solid reputation across 3 counties, and a commercial checking account that held the operating capital and my transition fund, the money I planned to live on once I formally retired. My wife Lorraine passed in 2021. Pancreatic cancer 4 months from diagnosis to the end. After that, my daughter Bethany was the only close family I had left. She and her husband Garrett had been married 7 years. I'd walked her down the aisle myself. He seemed solid enough, worked in logistics, kept his yard clean, coached youth soccer on weekends. When my cardiologist told me in February that I'd had a minor stroke and needed rest, Garrett was the one who suggested he could help manage the business invoicing and vendor payments while I recovered. Bethany was working full-time as a dental hygienist. It seemed like a reasonable arrangement. He had access to our accounting software through the office laptop, and I added him as an authorized user on the business account for bill payments only. I told him exactly what that meant: payroll, utilities, supplier invoices, nothing else. I was home for 6 weeks. My neighbor checked in on me most days, brought food, drove me to follow-up appointments. I wasn't completely out of commission. I answered emails, talked to my office manager twice a week, but I wasn't sharp. The stroke had affected my processing speed, and my neurologist was direct about it. Cognitive overload during recovery was dangerous. So I stepped back. I trusted Garrett to handle the routine. I found out what he'd actually done on a Thursday afternoon in April. My office manager, a woman I'd worked with for 9 years, called me sounding careful in a way that immediately made my stomach drop. She said 2 of our suppliers had called asking about overdue invoices. She'd pulled up the account to check balances, and the number she was seeing didn't match what it should have been. I asked her to read it to me twice. Then I called the bank directly. The account had been drawn down from just over $187,000 to $4,200. 41 separate transactions over 38 days. Some were legitimate, payroll, the usual vendor payments, but roughly $163,000 had moved in wire transfers and large checks to accounts I didn't recognize. One transfer description simply said consulting services. Another said equipment deposit. I had authorized none of them. I didn't call Garrett. Not yet. I called my bank's fraud line and told them I had not authorized the transfers. They flagged the account, froze further activity, and told me to file a police report. I did that the same day. The detective who took my statement was polite but honest with me. He said these cases were difficult when the perpetrator had legitimate account access, authorized user, known to the account holder, family relationship. All of it complicated the criminal threshold. He didn't say, "You probably won't see this money again," out loud, but I heard it underneath what he did say. I drove to Bethany's house that evening. She opened the door, and I could tell from her face she already knew something was wrong. Garrett was in the kitchen. I sat down at their table and laid out what the bank had told me. The number, the transfers, the timeline. Garrett's reaction was practiced. Concerned eyes, slow head shake, hands spread open on the table. He said he had made some judgment calls because a couple of equipment opportunities had come up suddenly, and he hadn't wanted to bother me. He said he fully intended to pay it back. He said the investments were going to come good and I just needed to give it a little time. Bethany was silent the entire time he was talking. She didn't look at him once. I drove home, sat in my driveway for a while, and thought about what the detective had said. The criminal system probably won't help you. Think strategically. I knew one attorney. I'd used him years back for a contract dispute with a subcontractor. I called him the next morning. He referred me to a civil litigation lawyer named Patricia, who specialized in business fraud cases. Her office was in St. Petersburg. Clean, professional, the kind of place where nobody wastes your time. She reviewed the bank records I'd brought and was quiet for a moment before she spoke. Authorized access doesn't mean unlimited access, she said. You gave him a defined scope. He exceeded it substantially. That's conversion, possibly breach of fiduciary duty if we can establish the trust relationship clearly enough. She paused. The harder question is whether he has anything left to recover. That was the question. Where was the money? She hired a forensic accountant and a private investigator who did a lot of business fraud work in the Tampa area. The retired DEA, late 50s, no nonsense. Started pulling on the threads within a week. What he found was not subtle. On March 8th, 11 days after the first unauthorized transfer, Garrett had put $38,000 down on a 23-foot Sea Ray cabin cruiser registered in his name. He picked it up from a dealer in Sarasota and had it docked at a marina in Bradenton. On March 19th, he wired $47,000 to a real estate holding company as a deposit on a 2-bedroom condo unit in Clearwater Beach. Pre-construction, scheduled to close in 18 months. He'd also paid off $14,000 in personal credit card debt, bought a new laptop and a set of golf clubs, and taken Bethany to a resort in the Keys for a long weekend in early April. She told me later she thought he'd gotten a bonus from work. There was no bonus. He hadn't worked a full week at his logistics job since February. The investigator's spreadsheet was neat and merciless. Of the $163,000 in unauthorized transfers, roughly $112,000 was traceable to identifiable purchases or payoffs. The remaining $51,000 appeared to have moved through a personal PayPal account and a Venmo account linked to a name the investigator was still running down. I filed the civil lawsuit on May 3rd, 3 weeks after first learning about the transfers. I also filed a complaint with the IRS. Patricia suggested it. Garrett had received what amounted to $163,000 in funds from a business account with no documentation of services rendered, no employment agreement, no 1099. The IRS has a form for reporting suspected tax fraud, Form 3949A. I filled it out carefully, attached the forensic accountant's summary, and mailed it the same week. The IRS doesn't confirm receipt or update you on their investigations. You file and you wait. But Patricia had done this before, and she said the same thing my previous analysis had taught me. When pressure comes from multiple directions at once, people crack faster. I didn't hear from Garrett directly after the confrontation at their house, but I heard from Bethany. She called me 3 days later. She said she needed to know if what I was doing was about the money or about punishing Garrett. I told her it was about both, and I wasn't going to apologize for that. She was quiet for a long time. Then she said she had a lawyer too, that she was filing for divorce. I hadn't expected that. I didn't know how to respond. I told her I loved her and that none of this was her fault. She said she knew. We talked for a while longer, carefully, around the edges of everything. When we hung up, I sat in the kitchen for an hour not doing anything in particular. Garrett's attorney contacted Patricia in late May. The initial position was that the transfers represented compensation for management services Garrett had provided to my business during my recovery. Patricia's response was a request for documentation, any written agreement, any time logs, any invoices, any record whatsoever of these alleged services being arranged, discussed, or agreed upon. Nothing came back. Because there was nothing to send. In June, the investigator confirmed that the $51,000 that had gone through the digital payment accounts had been used to fund a trading account at a retail brokerage. Most of it was gone. Bad options trades on individual stocks over a 6-week period. The account was worth approximately $3,400. Garrett had apparently decided that after successfully stealing $163,000, he was ready to try his hand at day trading. The condo deposit was refundable under certain contract conditions. Patricia filed a motion to freeze his assets pending the civil case. The court granted a preliminary injunction in mid-June, prohibiting Garrett from selling, transferring, or otherwise disposing of the boat or any other identifiable asset funded by the unauthorized transfers. The process server found him at the marina in Bradenton, sitting on the boat with a cooler. The IRS sent Garrett a letter requesting documentation in July. The investigator confirmed this through a source. Garrett had 30 days to respond, with records explaining the source of funds for his purchases in the first quarter of the year. He had no legitimate explanation to give. His attorney called Patricia the same week the IRS letter arrived, offered $55,000 to settle. Patricia relayed this to me and waited. I said no. Garrett's attorney called back 10 days later with $80,000 and a request that I withdraw the IRS complaint. Patricia explained calmly that the IRS operates independently and that once a fraud referral is filed, I have no mechanism to withdraw it even if I wanted to, which I didn't. August was quiet, the kind of quiet that has weight to it. My office manager kept the business running. We lost one client who'd heard rumors about the financial disruption, but kept the rest. I went back part-time in August. Slower than before the stroke, but functional. I could see a clear line again between what needed to happen and how to make it happen. 31 years of running a business does that for you. Problems have components. You address the components. The trial was set for October. Garrett arrived at the Hillsborough County Courthouse, looking like someone who hadn't slept well in months. His attorney had managed to get the criminal fraud charge knocked down to a civil matter. The DA had declined to prosecute given the authorized access issue. But the civil case was solid, and Patricia knew it. Our forensic accountant testified to the trail of transactions. The investigator testified to the asset purchases. My office manager testified to the scope of what Garrett had actually been asked to do. Garrett took the stand. His attorney walked him through the version where he had acted as a genuine business manager, had made good faith decisions under difficult circumstances, and had intended to reconcile the accounts once his investments came through. It was a performance. I watched the judge watching him. Patricia's cross-examination was methodical. She asked him to identify any document, any text message, any email, any handwritten note in which I had authorized him to use business funds for personal investment purposes. He said there was no formal document but that we had a verbal understanding. She asked him what specifically I had said. He couldn't recall exact words. She asked him when this conversation had taken place. He said sometime in February, around when I was first recovering. She then produced my medical records showing that for the first week of February, I had been under sedation in a hospital room. She showed the judge the boat purchase receipt, the condo deposit wire, the credit card payoff, the golf clubs. Mr. Garrett, she said, did you purchase a set of Titleist irons in March using funds transferred from your father-in-law's business account? He said he had considered it an advance against future compensation. Was there a written compensation agreement? It was understood. Between you and whom? He had no answer that helped him. The judge ruled 11 days later. She found Garrett liable for conversion of business funds, breach of the duty of care owed as an authorized agent, and unjust enrichment. Judgment for the plaintiff in the amount of $163,000 plus prejudgment interest, plus attorney fees of $38,500. Total judgment, $204 immediately. Patricia filed to enforce immediately. The boat was seized by the court and sold at auction in November. After the marina storage fees and sale costs, it netted $29,000. The condo deposit, $47,000, was recoverable under the contract's fraud provision. Patricia filed with the developer directly, and they cooperated. They had their own interest in making sure the contract wasn't tainted. That brought the recovery to $76,000. The IRS, moving at its own pace, had assessed Garrett for unreported income. Their number was $148,000, with taxes, penalties, and interest totaling just under $44,000, due within 90 days. Garrett had no income. He'd been let go from his logistics job in September. Once word got around in that industry, it's smaller than people think. He had no savings, no assets left outside what the court had already seized, and now an IRS liability he couldn't pay either. In December, he filed for Chapter 7 bankruptcy. Patricia had prepared me for this possibility. Judgments arising from fraud are not dischargeable in bankruptcy under federal law, 11 U.S.C., Graph 523A2 and A4. The bankruptcy trustee could liquidate whatever remained of his non-exempt assets, but the judgment would survive and follow him. Every paycheck he ever earned, every bank account he ever opened, would be reachable. Bethany's divorce was finalized in November. She'd moved into an apartment in Largo, about 20 minutes from my house. We'd been careful with each other all year, not cold, just careful. The way you are when you're both still figuring out the shape of something that's changed between you. On Thanksgiving, she came over and we cooked together, just the two of us. And somewhere around the time she was mashing the potatoes, she started crying. Not about anything specific. Just the year, I think. I didn't say much. I handed her a dish towel and stood next to her at the counter. I recovered $118,000 of the $163,000. Lost the rest to legal fees and the gap between the auction value and what things were actually worth. But Patricia reminded me that the judgment stood. Whatever Garrett earned going forward, I had a claim on it. I was back at the business full-time by January. The stroke still slows me down some. I'm not who I was before it, and I've accepted that. But I kept the company. I kept the employees who depended on it. I kept my daughter. In February, I got a voicemail from a number I didn't recognize. It was Garrett. He sounded hollowed out. He said he didn't expect me to call back. He said he knew he had destroyed everything, and that there was no excuse and that he was sorry. He said he hoped I would find a way to forgive him someday, not for his sake but for Bethany's. I didn't call back. Forgiveness is something I think about differently now than I did before Lorraine died, before the stroke, before all of this. I used to think it was something you gave. Now I think it might be something that happens on its own, slowly, if you live long enough and stay honest with yourself about what you're carrying. I don't know yet whether I'll get there with Garrett. Maybe, not today. What I know is that I did not let it go unanswered. I did not accept the first version of events where a man steals from you and then calls it a misunderstanding and the system shrugs. I built a case, one document at a time, the way you build anything that's meant to hold weight, and it held. The boat is gone. The condo deal dissolved. The money, most of it, came back. On a Saturday morning in March, I drove out to the marina in Bradenton with a cup of coffee and sat in the parking lot for a while, looking at the water. Not for any particular reason, just to mark it, I suppose, just to feel the end of the thing. Then I drove back to work.